And welcome to episode 6 of 30 Minutes with HR. I'm very excited to have you join us again for this special and another educational episode. If you're watching live on AAU TV. 30 Minutes of HR is a partnership program between KUSI Consulting and the Association of African Universities. And you're watching live right now on the Association of African Universities Facebook page. Today we have another educational and insightful topic. We're going to be discussing employee and employer relations pertaining to grievance, discipline, and termination. And we have a special guest here. Hello, welcome, Senyo.
Thank you.
So now, today we have Senyo M. Adjabeng, and I'm actually going to have Senyo introduce himself to you all.
Great. So, I'm the founder of a firm, CAS LLC. It is a labor consulting and dispute resolution firm. I've been in employment relations for the past 15 years and have handled a few issues. I'm also listed as a mediator and arbitrator with the National Labour Commission.
Okay.
So I get to see a lot of action pertaining to when employment relations or employee-employer relations go bad, how it is resolved.
Okay.
Right.
I think you're being modest when you say you've handled a few. I mean, certainly someone in your profession must have handled quite several. Yeah?
I must agree.
Well, today
Yes.
we look forward to you sharing some of that action with us because I think it's really important when we talk about employee and employee relations. You know, sometimes I think employers really are not aware of their role when it comes to dealing with employees, and employees also are not aware of their rights.
Yeah.
So this whole show, the 13 pilot episode, aims to do just that, educate employers and also let employees, make employees aware of their rights. So now, we actually got the conversation started before we went live on air.
Sure.
And I was asking you if the way that the title is for this show, if it's in the right order: grievance, discipline, and termination. And you were educating me a bit on that.
Yes, and I was
Okay.
saying that the right order would be grievance,
Okay.
discipline, and then termination.
Interesting.
Because grievance is like a formal complaint,
Okay.
and then discipline has to do with resolving misconduct.
Okay.
And then beyond that, if misconduct is not effectively dealt with, then it goes on to the separation of the contract of employment, which is termination.
Okay.
Yeah.
So now, can an employee file a grievance after termination?
That would be the appellate process
Okay.
of appealing
Okay.
or filing an appeal
Okay.
to the decision of termination of employment.
Okay.
So a grievance basically is always supposed to be filed when an employee has any issue about the employment relationship. It could be with a colleague, it could be with an immediate supervisor, it could be with a manager, it could even be with the organization as a whole.
Okay.
But grievances have to be formally written, and that is what makes them grievance.
A grievance.
And once it is filed, it has to be taken care of.
Okay.
It has to be resolved.
Okay. We're getting just a bit ahead because also before we went live on air, we were having a conversation. So my HR expertise is more from the U.S. perspective. So I'm
Yes.
still learning how things are done in Ghana. And in the U.S., it was more, when grievances were filed, they were mainly from union employees. And they were usually filed after the termination.
Okay.
You know, I'm sure you can file a grievance before, but from what I was used to, it was more after.
Yeah.
So I just wanted us to clear that up. All right, so now there are two scenarios that I shared with you
Yes.
during the week. I'm going to read the first scenario, and then we're going to discuss whether or not, you know, this was a case where the employer could have gone about their relations differently, or whether it was the employee's fault. Yeah. So after 28 years at the Massachusetts Institute of Technology, MIT, the Dean of Admissions, Marley Jones, submitted her resignation in 2007, the day before it had come out that Jones fabricated her education credentials on her resume, CV, when she first applied for a job at the school in 1979.
Right.
1979, okay? And it wasn't until 2007 that it came out that she had pretty much lied. So now, she quote unquote resigned, but I'm sure being in HR, we know that she was probably forced
Yes,
to resign, right? So has she not been terminated? Would this have been an unfair? Has she not chosen to resign? Has she been terminated? Would this have been an unfair termination?
No, it wouldn't have been. Normally, you know that in HR, when we advertise for positions, we have specific conditions and terms based on which people vie for the job and are chosen. So normally the best person is chosen for the job. Now, if any of the candidates misrepresent the facts of their information that they put forward, then it means that dishonestly, they might have gotten ahead of other candidates who might have been more qualified for the position. Under those circumstances, it means that they would have gotten the position on grounds of deception and false representation or misrepresentation. And that normally would constitute an offense, which is resolvable by the termination of the employment. So under these circumstances, the organization would be fair or would be lawful in terminating
even
the
after
employment.
all those years. And I mean, is she the only person that should be terminated? How about the person that hired her into this role? They obviously didn't do their job.
Well, yes. So it can be handled in phases. Definitely those who did the recruitment and especially the onboarding process missed out on the effective background checking. Now, if the background of the candidate or the employee had been checked during the onboarding process, then it would have been found out and they would have been disqualified and their employment would not have been confirmed. So the internal recruitment people would then have to face disciplinary processes towards possibly a form of sanction depending on the schedule of offenses and sanctions of the code of discipline of the organization. So the first would be definitely that that offense has a criminal element. So for criminality, definitely you cannot retain your job. And so the employer would be right in terminating. But you know, in HR, we have a way of going about these things. We have hard HR, which is the strict appliance or application of policy and law and regulation. And then we have soft HR that looks at the human side of handling issues. So like you said, the relationship between the two, the employer and the employee, might have led to an understanding that, yes, this was 39 years ago, and you might have been young and so on. So definitely for purposes of transparency and fairness to the application of regulation, it would be good for you to step aside. The best way of doing that is resigning, so that we can both go on with whatever we have to do.
So in this case, do you think the HR who was in charge of hiring her, if they were still employed?
If they were still employed, they would have to explain this anomaly.
But they wouldn't normally terminate someone who makes that kind of mistake?
It depends on the kind of management leadership in place. Some may see it as a very serious, you know, HRM has risks, and employees normally come into employment with risks. So assuming this was not found out and the organization had lost money or brand or something, then of course the ramifications would be more serious. But under the circumstances, I don't think this was just something that was found out, and I don't think that the organization lost so much in any way. So perhaps the sanction of the recruiters may not be termination, but a lighter sanction, such as maybe suspension or something else.
Okay.
Yeah.
She actually benefited from this. She went on to write a book. You know, she's now an author. So I don't feel sorry for this woman at all.
Right.
So now the second scenario is quite similar. Yeah. So there was a similar incident in 2017 when the then general manager of MIS at SNIT, that's the Social Security and National Insurance Trust, Caleb Afaglo, who was appointed to the position in 2015, did not hold the right qualifications. He used a fake degree. And I don't mean one fake degree. I mean his bachelor's, his master's, his doctorate, and was therefore relieved of his duties.
Yes.
So two different scenarios where one was, I'm sure, forced or asked to resign, and the other was sacked.
Yes.
So, I mean, in Caleb's case, like, did he stand a chance if he had filed a grievance?
No, he wouldn't have had a chance, because in that scenario,
Okay.
Issues escalated to that point where the backgrounds were being checked by the national authorities, security authorities, because the organization had lost a lot of money regarding a project,
Exactly.
an ICT project.
Exactly.
So this was very huge amount of money, and so I don't think he would have stood a chance. And it is under these circumstances, for example, that those who recruited him, those who were responsible for onboarding him and checking and confirming his employment or otherwise, that this is where they can be in trouble. Because had they checked, then this individual would not have made it into the organization and become a risk to the organization. But under these circumstances, the organization has lost so much money on account of the presence of the individual. And so then heads must roll to correct things.
Okay.
And beyond that, employers have to, when they find such offenses, when people go through the all the checks and the policies put in place to prevent some of these things, the policies have to be rewritten. They have to be relooked at within the context of the new development, and the regulation and policies tightened further.
Perfect.
So that organizations don't suffer some of these.
I'm very glad that you mentioned that. So you don't just come across these situations and decide to move forward with your current what do you call it, policies. It's good for employers to also go back and review their onboarding process, review their policies.
Because when it hits you again, it would cost more.
Exactly,
Yeah.
exactly. Interesting. So we chose these two specific scenarios because they happen on two different continents, you know, just to let you all know that incidents of termination, discipline, and grievances happen all over the world. People are getting sacked every day, every minute, but we need to stop and really evaluate what the process leading up to terminations are, okay? If you're tuning in, thank you for tuning in to episode 6 of 30 Minutes with HR. You're watching us live on AAU TV, and today we have our special guest, Mr. Senyo M. Adjabeng. So now we're really about to get started. All right, so let's say you have an employee who has no infraction whatsoever in their personnel file. I mean, there's no write-ups, nothing. And then one day, they're terminated. Their job is just terminated. What advice would you give to this employee? I mean, what disciplinary process should employers follow when leading up to termination?
Okay, great. So two things can lead to termination of employment. Either misconduct, that is misbehavior, or non-performance. Both of these actions normally would still breach the contract of employment to the point where the employer would have cause to terminate.
Okay.
Now, sometimes employees may not have the capacity to continue to do the job that they've been asked to do, either illness or any other thing, or employees may die. So then the contract is terminated. All these are fair termination of contracts. Now, if an employer decides one day just to terminate employment, they have to have cause. And cause is normally lawful ground on which the termination must occur. And under those circumstances, the employee must have done something wrong. The employee must not be performing, or generally, performance means able to adequately meet the targets of work for which they've been given. And so that would be lawful. Once you terminate without cause, it is seen as unfair termination, and the employee would immediately have the rights to contest and have the rights to compensation if that contestation is successful. So how does an employer ensure that they do not terminate unfairly? They have to have a ground for the termination, and that ground is outlined in law most of the time. And in the Ghanaian law, it's outlined in sections 15, section 17, and section 62 of the law. Generally, there must be a lawful ground for the termination. Once the ground does not occur, then it is unfair. Then the employee would file either to the courts or to the National Labour Commission, stating the specific infractions and then claims for compensation. But in Ghana, normally, compensation or damages for unlawful termination is normally compensation, and compensation is normally determined based on basic pay per month, etc., etc. Actually, the Supreme Court has given compensation of up to 24 months for unlawful termination.
Really?
Yes, up to 24 months for unlawful termination of employment.
That's 2 years.
That's 2 years.
Wow.
2 years basic salary.
Wow.
And that's the highest that I believe we've gone so far.
I wonder how many employees are not aware of that, you know? That's true.
Yeah.
Interesting. All right, so we're going to take a quick break, and then when we come back, we're going to continue this very educational conversation with Senyo. So we'll be right back.
My name is Dr. Violet Makuku, a quality assurance expert with the Association of African Universities. The Association of African Universities is here with the African Quality Rating Mechanism, internal institutional evaluation tool that can help you improve the quality of higher education, whether it is in teaching and learning, in ICT, in infrastructure, financial management, university management, and all the other aspects whose quality should be monitored in the university. Kindly follow the provided links for you to understand more about the African Quality Rating Mechanism, institutional evaluation process, and also to get hold of the form that you can use to express interest. AAU, the voice of...
Good afternoon, and welcome back to episode 6 of 30 Minutes with HR. Today, we are discussing employee and employer relations as it relates to grievance, discipline, and terminations. And again, we've welcomed our special guest for today, Senyo M. Adjabeng. Now, before we went on commercial break, you mentioned laws. You know, so this program here on AAU TV, 30 Minutes with HR, we try as often as we can to provide content that the global community can I guess, benefit from. You know, but we operate from Ghana, so sometimes we do end up making references to our demographic. So now when you mention laws, can you be more specific? You know, and if these laws obviously are not just in Ghana, and everywhere, whatever country you're watching from, you can have access to these laws.
Yes.
Yeah, so what laws are you referring to?
Great. So, first of all, Ghana subscribes to the ILO conventions on labor and employment. So, we're subject to that because we have ratified most of those conventions. Okay. And so the hierarchy would be the ILO conventions, based on which some provisions in our national constitution of 1992 have been spelt out. Okay. Then based on that, we have the Parliamentary Act of 2003, the Labour Act, and then, so that's an act of parliament. Then under that, we have two regulations, legislative instruments. 1822, that is the Labor Commission regulations, and 1833, those are the labor regulations passed by the Minister for Labor in 2007. And so these are the basic employment laws, but we have other ancillary laws like the Workmen's Compensation Law, PNDC Law 187. Then we have the Health and Safety Regulations also, which all come together to regulate employment relationships in Ghana.
Interesting. Yeah. Interesting. Some of these I've never even heard before, and I'm in HR. You know, this is why I love this show, because honestly, every episode gives us a chance to learn from one another.
Yes.
You know, no one knows it all. So I'm just very fortunate and happy to have you here, and that I'm able to learn from you as well. So now, when we talk about discipline, grievance, and termination, when an employee wants to file a grievance, who do they file with? And who's in charge of following the steps, disciplinary, termination? Who handles that within an organization?
Okay, good. So let me start from this point. One ground for termination, for unfair termination, is where an employee actually walks away from the job with or without notice and files a claim of unfair termination on two grounds. One is sexual harassment or ill treatment, and the other is an imminent hazard and unsafe environment, in the workplace. So on these two grounds, an employee can walk away from the workplace and then claim that they were unfairly terminated.
Really? Even if they just walk away from it with no, they don't do any kind of reporting?
They can decide to do it formally or not formally. And they can claim that they have been unfairly terminated. However, it has to be on the basis that they made repeated reports and nothing was done about it. So the repeated report means that they should have reported at least twice. So how do they make that report? They make the report officially through a grievance. That either I'm being ill-treated by my boss, I'm being abused, or there's just something about the employment relationship that makes me uncomfortable as an employee. Under those circumstances, they file a written complaint and direct it to their immediate supervisor, who would have a time limit to resolve the problem, go into it, investigate it, and try to resolve it. If not able to, it may go to either the department head or the manager. If it's not able to, and then it may end up at HR. HR then would engage everyone who's been trying to resolve it together with the employee to have it resolved. If it is not resolved, then the organization has to, the HR may now take it to either executive or directorial level for it to be resolved. If it fails, then it becomes a dispute that possibly would have to be resolved outside of the organization. And therefore, yes, so the employee now can take legal action with the courts or the National Labour Commission or any other adjudication body like the SHRAJ, the Commission on Human Rights and Administrative Justice. Any of those bodies can then, outside of the organization, try to resolve it. And before resolving the dispute outside of the organization, the employee can decide to walk away and claim that they've been unfairly terminated.
Interesting.
And so that is how grievance can travel right through the organization to the top, and where it fails, then they would then have the right to be able to use an external adjudication body to do that. There is, however, in our laws, an opportunity for a dispute resolution professional, like a facilitator or negotiator, to come into the organization upon the request of both parties, the employee and the employer, to try help them to resolve the dispute finally before the dispute is able to leave the organization. So every effort normally is made to resolve grievances because they have the potential of traveling and becoming a huge dispute that may cost the organization.
Well, I just hope organizations are aware of what the process is, because obviously there's a process.
Yes.
You don't just, you know, because of any ill feelings you have towards an employee, decide that that employee is terminated. Now,
Yes.
I mentioned before that the previous company I worked with, we had unions,
Yeah.
and that's how I was actually introduced to grievances, because union employees, I think, have more of a reason or more of a
Yes.
to file grievance. So in that case, do they also report it to their supervisor, HR, and their union?
Definitely. So they would normally notify their unions,
Okay.
but still go through their supervisor up to the HR level.
Okay.
At the HR level, the union will now be brought on board fully as a party in the dispute,
Exactly.
who would now advocate on behalf of the employee as a representative and an advisor.
Okay.
So they would then take it on with management at the HR level, and then also at the senior management, directorial or executive levels, to have it resolved.
Okay.
If it is not possible, then the union now can use other mechanisms available to them within the lawful relationship to be able to do that. And that's where they can use lawful strike or other tools that are available to them, like filing a claim in court and a suit in court and so on.
Okay.
So when there's a union in the organization, it starts on the shop floor and then rises to the HRM level or the managerial level, and then the union now steps in fully and represents their member, the employee.
Interesting. You know, these shows, to me, 30 minutes is not enough. It's not enough because they're so educational. You always end up having so many questions, you know, but we have about 4 or 5 minutes to wrap up. Now, before the show started, you mentioned that I think over 90% of the cases, the termination cases that come to the Labor Commission are usually unfair.
Yeah.
Wow. Can you talk a little bit about that without actually giving any case away?
Sure. Now, employees are becoming more aware of their rights, and especially their rights to claims of compensation when it comes to unfair termination or unlawful termination. So they file complaints at the National Labor Commission. The National Labor Commission reports, since it was established in 2005, shows that over 90% of cases that are filed, especially by employees, are for unfair termination and claim for compensation. That means that employers might not be doing something. But I can explain. In the past, we had the traditional way of handling employment relationships where employers felt that they could terminate by just giving notice.
Exactly.
Today, and since 2003, the law now requires that you terminate on grounds. You may or may not inform the worker about the grounds for which they are being terminated. But if they file claims against you, or they file a writ or suit against you in any law court or before the National Labor Commission, you would have to prove that you terminated on lawful grounds. And so that sometimes brings about some challenges for employers who believe that they can terminate without cause, or they can just terminate with notice, only for them to come and realize that no, there are specific grounds on which you can terminate.
Exactly.
Yes.
Exactly. I'm very happy to hear that more employees are are realizing that their rights on the job, because they do have rights.
They do
And I
have
feel
rights.
like this will push employers in a way to just do right by the employees, because let's be honest, without your employees, you really don't even, you can't operate, you don't have a business. So now, do you have any last words, any tips you would like to share with our viewers before we end today's
Yes,
show?
when it comes to employment relations, especially in Ghana, depending on where it's coming from, employers think that the regulations of law and employment law favors the employee, and the employees also think that the employer is too powerful, and etc., etc. Unions think that exactly their rights are not protected enough by the law. But I just want to say that the regulations often advocate a relationship, and once it is a relationship, then dialogue is very important, and communication.
Exactly.
So employers and employees need to continue talking. They need to create environments and avenues to communicate more and to be more transparent to each other, so that mistrust would be eliminated in the relationship, so that both of the parties can work towards productivity. And I'm sure you know that productivity in Ghana is rated very low. It's just because a lot of the time employers and employees are engaged in fights and arguments and other interactions that are not productive. So productive time is used for mending and sustaining the relationship, when really just transparency and communication avenues can be created for this to happen. And so employers should open up more, give more communication and information to workers, and trust will be built, and then productivity would shoot up.
You've used a few of my favorite words: communication, transparency, and trust.
Yes.
You know, when you're operating a business and you have others involved, you definitely have to honor those three words. They should be part of your company culture. Communication, transparency, and trust. Thank you so much, Senyo, for coming on today's episode.
You're welcome.
On last week's episode, we mentioned that we were offering free consultant services. We have 3 winners that we have selected, and I'd just like to congratulate Kamal Idrisu, Comfort Awadzi, and Martin Avino. I would like to congratulate them for winning KUSI Consulting's free consultation services, and we will get in touch with you on how you can claim your prize. Again, thank you all so much for watching us live on AAU TV. We have Senyo M. Adjabeng here. He is your labor expert on termination, on grievance, discipline, and termination. So I really hope you found today's show insightful and educational as always, and we will see you next week, Wednesday. Thank you.